It's Lisa from Been There, Got Out, and we are now on For Real with family lawyer from New York, especially New York City and Westchester, Cara Bellew. She works for Rower LLC, and we met in October. There she is. We met in October in Manhattan, and Cara was on a panel talking. I don't remember what the topic was, but she was on a panel talk. There she is. And as she was talking, I was listening, going, "Wow, everything she's saying is in complete alignment with what we think too." And so I pounced on her after her panel and asked if we could have a conversation. And since then, I've been lucky enough to meet you in real life and share a couple meals with you, which has been really fun. And she agreed to do this Instagram Live, so I'm just thrilled because, like I said in my caption, Cara is one of those unicorns of attorneys that really gets it, and it's not just because she's had minimal background experience with domestic violence victims, but she's actually been trained extensively. So Cara, why don't you introduce yourself and tell us a bit about your background?
Sure. I'm Cara Bellew. I'm a partner at Rower LLC. I've been with the firm for 7 years. Prior to that, I was at Sanctuary for Families, which is the largest provider of services to victims of domestic violence in New York State. It also has the largest legal center in the country, specifically devoted to working with and protecting the rights of victims of domestic violence and victims of trafficking. And I really, I came to Sanctuary after law school, where I spent a considerable amount of time working alongside professors and at an institute there, the Domestic Violence Institute at Northeastern School of Law, which is where I attended. Prior to that, I received my master's in social work at Boston University, which was really where I started to develop an interest in learning more about domestic violence and how to help protect survivors.
So it's not just a domestic violence training, it's also this social work background that you bring to the table. Do you ever meet other attorneys who have that kind of background? Because we certainly haven't met too many.
There are certainly people who have it. I'd say we're a little fewer and farther between, but
okay, I just saw a quick question fly by. What states are you licensed in? Okay.
Just New York. And primarily my practice is focused in Manhattan, Brooklyn,
okay,
and
so
Westchester.
let's start talking about the meat of what I wanted you to come on and say. I know we had a couple of ideas, but the first one, we were talking a lot about trauma, and we'll get to that a little bit later, but the main thing is people in these situations feel really, really helpless. And often they're coming out of these relationships where the other person is being the authority, and it's very hard for them to make decisions. And part of what we do, and I think what you do too, is you help teach clients how to advocate for themselves. And it seems strange, but often our clients have to learn how to advocate for themselves with their own attorneys, because most people have never been through anything like this before, and especially a high conflict situation, it's like even more confusing. So how about we talk a bit about what people can do, what our clients can do to advocate for themselves, to start learning how to stand up for themselves, starting with their own attorney who's supposed to be an advocate for them as well.
Sure. I mean, I think it's really important that whoever you hire, you feel is a good match for you. A match in temperament, a match in strategy, a match in goals. And the way I practice, I mean, I tend to over communicate, because I want people not only to always know exactly where their case stands, but I want them to understand the myriad options that are available to them as to how we can resolve certain issues. And I think to really understand those options, you have to talk through the cost associated with each of those options. You must talk about the time frame associated with each of those options, because they can be materially different. And like anything else, options comes typically with pros and cons. But I don't think you can really make informed decisions if you're not being guided by someone who's really laying out those different options for you. And I think clients sometimes just can follow the lead of their attorney, which that's not a bad thing, certainly. But I think the attorney's job is to really set out, what are these different options, and then together making an informed decision about
is
how
there
to
any
move forward.
common situation that you can think of where someone's like, this is what I want to do? Let's say I want to get full custody of my kids.
Yes. That's a common request. So, to sort of build off of that example, getting full custody of one's children is not always, something you just run into court and request. It's very much guided by, okay, what are the circumstances? What's happening right now? And if we're looking to change that, what's the standard that we have to meet in order to change that? And what is ultimately that's going to do to the case in terms of cost, in terms of time, and also in terms of your children? Because typically you do not litigate the issue of custody without your children being embroiled and directly brought into the litigation, meaning, attorneys will be assigned to children. I've seen judges assign attorneys to children as young as a year old. So oftentimes a forensic evaluator will be appointed, that's a psychologist typically, or a psychiatrist who is appointed to evaluate the entire family. That process in and of itself is, typically almost a year long. So saying you want to fight for custody, you have to really know what you're fighting for, what that looks like, what that really means. And that's usually where I start when someone says that, I'm going to fight for custody. I want you to go in and get me custody. And then I usually say, okay, tell me what that means to you, because what that means to you may be very different for what that means in a litigation setting. And that's where I start, because I want to always make sure we're speaking the same language.
I guess that was a really good example, because that's the example we hear most of the time. Yeah. Okay. Right. So then another thing that I was talking to you about that I had experienced a little myself was how to avoid the pissing contests. You want to talk about what the pissing contest is and being clear that I don't want to pay for that?
Right. You and I had spoken about this and I've certainly had clients express this to me, that sometimes in very high conflict cases, the attorneys become so at war with one another that they're not actually moving the needle forward on what needs to be done, because they're so focused on and angry with each other, which ultimately does not serve your client's interests. So it's interesting, because I think sometimes clients fall into two buckets. There are very pragmatic clients who say, enough of this, don't respond to that email, don't forward me those emails, ignore that, versus there are others who enjoy the fight, because to them that feels like they are being protected. They have a mouthpiece for all of their upset and all of the wrongs that they feel they have suffered, and now they've got this person who's just calling it out, and that feels like protection. So that's another opportunity, I believe, to have that conversation about how do we want to communicate with one another, and does this feel like you're being protected? Because that, for me personally, that's not my style. My style is I am strategic about my fights. I'm not going to scream and yell. I'm not going to alienate the other side, because what that means is the other side's not going to pick up the phone and call me and have actually constructive dialogues, because they've determined that I'm so unreasonable and so angry, and I'm constantly advocating and posturing that they can't make headway with me. So to me, that doesn't serve the client. But I also recognize that sometimes the client wants you to throw your weight around a little bit. And, you know, depending upon the circumstances, you know, that's an opportunity, I think, to speak to your client about, okay, how are we gonna work together? And look, ultimately, if you want someone because it makes you feel protected to have someone screaming and yelling and be really nasty, you can absolutely find that person, but it's not me. You know, and I have no reticence about saying that, because again, it goes back to that matchmaking, right? Like, how are you going to work well together? And you know, different clients want different things. You know, I'm not the right person for every single person. I get that. But I think to your question around like the paying, you know, paying for all of this, all of those nasty grams back and forth, they come at a cost, because you're, you know, for me, I'm sitting there, I'm writing emails, I'm drafting letters, that the client is paying for that. And I would think that as a client, when you're paying for that and it is not yielding an outcome that you can see, and it's not making any measurable difference in your case, it's understandable for clients to say, I'm not interested in this. Like, get me results and stop all the nastiness.
And another thing you said, how clients can advocate themselves, is being clear. This seems like it tails into what you just said. Like, go ahead.
Yeah, I mean, being clear what works for them. And I tend to ask clients, do you want me to forward you every communication? You know, my sort of standard way to work with a client is everything that comes into my office, whether it is to me, my associate, the assistant on the case, everything gets forwarded to a client so that they have their own working correspondence file, and they're kept very much in the loop as to what's being done on their case. Some clients have said, I do not want that. I would rather you send me a summary of where we are at the end of every week. I do not want to see those nasty emails from opposing counsel, because it makes me feel horrible. Totally valid point, you know? And I have learned over the years, I never send clients things late at night, things that are going to be upsetting to them. You know, some nasty email or letter that comes in from the other side. Who wants to get that at 10 o'clock at night? And then they just sit and they worry. So I, you know, particularly when a client expresses upfront concerns around that, I try to address that head on, so that we're working in a way that, you know, is ultimately going to be helpful to them, as opposed to harmful. That's the last I want to be, is harmful during a period of time that is already traumatizing.
Yeah. I mean, one thing I remember from my divorce attorney, who was lovely, was he was saying there's ways to save money, and what we can do is I won't even look at things that come from the other side, Lisa. I'll send it to you, and then you can come up with the response and then send it to me, and then I'll take a look at it and send it back. What do you think about that kind of thing?
That's a hard one to answer. I mean, I think that is case specific. It really depends what's going on at the time. You know, there are things that just have to be responded to, and have to be responded to in a particular way, which, I don't know that necessarily every client would know that, understand like the reasoning for that, if it's something involving the court or a deadline. So I think, it's definitely a possibility. I wouldn't rule it out, but I think it would have to pertain
Good
to
answer.
particular things.
Okay, now let's talk about how trauma, because that's always a huge part of our clients' backgrounds. So how does trauma, how can it interfere with the case moving forward? I have my own ideas and information that I've gotten, but I want to hear what you think.
Trauma can play out in a case in many different ways, and I think it really depends on the client's own experience and how they have internalized that trauma. I have seen people be so traumatized that they just completely shut down, and that becomes difficult when the case is moving forward. There are things that need to be addressed, and the client feels so traumatized even talking about it, that they can't sort of be responsive and more fully participate in the process. So that's definitely one thing that can happen. I think trauma can manifest itself, in extreme emotional reactions. It could be anger. It could be, just so highly emotional, which is, again, it's understandable when someone has been through what many people go through to either get to this process, or once they're in it, the process can become traumatizing in and of itself, because a lot of the same dynamics and behaviors that people were contending with in a marriage get played out in a divorce, and the stakes feel higher. They often are much higher, so that can be very difficult too. But again, I think that's where certainly my social work background has come to be an incredible asset. There's a sort of saying in social work school or beyond, which is, you meet the client where they are. And I have when I just was first starting out, I would sometimes miss the mark, because I would think, oh, they want me to be this way. And so that's how I have to approach things. But then when you step back and you think, but that's not where they are. I've got to adjust my approach to this so that I'm really meeting them where they are, and I'm helping them to move forward in a way that feels manageable, but it feels empowering, and they also feel like I'm protecting them.
So important. As you were talking, I started thinking about the discovery process, and how for a lot of our clients that is traumatizing. It's an invasion of privacy, and I'm talking about when somebody asks for all of their records and their background and years worth of their financials, and sometimes I know in my case I was asked for my journals, private text messages, things like that. And so people often get paralyzed. Like a number of our clients will say, there's a financial affidavit, I just can't deal. Like I don't have time to do this. I can't. How do you handle that when let's say, like you said, there's things that have to be done by a deadline for court, and your client is like, I can't handle it. I can't do it.
Mm-hmm. So that's a very good example, and it's a typical response, because it can feel utterly overwhelming, particularly when you're working full time, you're raising children. Your divorce can become a full-time job. So, at my firm, every case we have a whole team. So it's myself, it's an associate, it's my wonderful assistant, and we really try to make available the things that will be helpful to a client to get through that. I mean, sometimes clients will call my assistant and they'll spend an hour. She gets all of the passwords. She downloads every single thing, so that they never have to think about it again. And it's being done by someone who's a non-lawyer, so they're not paying my hourly rate to download statements, which understandably someone wouldn't want to do, but they're also just being, someone's holding their hand and someone is saying, I got you, and I'm going to get this done. I need maybe 20 minutes of your time. Sometimes like that's it. I just need the passwords. Just tell me what these accounts are, and then we take it over. And I think that that can be a way to just alleviate some of the like physical burden and the time associated with having to do that. It doesn't obviously address the feeling of being violated from a privacy standpoint. And there's not that many ways around that, because divorce does entail full financial transparency. I mean, there's obviously, exceptions to those things.
Yeah,
broad
yeah.
strokes.
Okay, another thing that we always hope to avoid is litigation. And I think most lawyers try, except certain types, most lawyers try to do it the amicable way. As I imagine you do, you want to keep your clients out of court. It's much cheaper, less time consuming, etc. But how do you know when it's time to take it to litigation? Or maybe I should make it broad. How do you know when it's time to take a different approach to a case?
So that's a very good question, and it depends. That's my relationship for everything. It depends. I mean, you can, when you're operating completely outside of court, you are doing so in a way that assumes everybody's going to be cooperative, everybody's going to be transparent, and on balance, everyone is going to be reasonable. So there are certainly cases where all three of those things happen, and you can run the case in a way that keeps everybody out of court, but keeps the case moving and ultimately gets it resolved. I have plenty of cases where we've worked in that way. But when you don't have those things, and you do not have deadlines that are actual deadlines, meaning imposed by a court, as opposed to, myself and the other attorney saying, okay, we're going to exchange statements of net worth on Friday. Friday comes and goes. Okay, then you get into chasing. When are we going to receive it? Ours is ready. Why aren't we moving this forward? And at a certain point, you have to decide, are we going to continue to spend time and your money chasing the other side to do what they've said they're going to do, or are you going to get a court involved? And that's really a perfect opportunity to have that discussion about options. Because, running into court, that obviously that changes things, but sometimes, it changes things for the better. I mean, courts exist for a reason. So in as much as people scarcely come into my office and say, oh, I can't wait to go to court, that would be my first stop. No one said that. But it also doesn't have to be this big, bad, horrible thing that people conceive it to be. And I think once people really understand, okay, well, what can the court do? What does it do? And how could it be helpful in this situation? That oftentimes, although not always, but oftentimes it does sort of disabuse people of this idea that a court's going to take control of my life. I'm going to lose my children. I'm going to spend $100,000 and I'm going to be worse off as a result of it. So, I think that's a common misperception.
And we talked about, I mean, this was almost the title and the idea theme for this conversation. We talked about how people really want to settle, especially in the high conflict cases where it's dragging on for a while, and they're like, I will do anything to make this stop. And you said that that's not a good place to be in. But we get some people who are like, I don't want to be here. My case is different. I really don't like the legal system. Like, yeah, none of us want to be there, but we can't just make it stop. So what do you do? Like, how do you handle it? Or what are your thoughts on desperation and settlement?
Well, I think anytime you signal, particularly in a very high conflict case, if you are signaling to the other side that either you as the attorney are fatigued and you just want it to end, or that your client is absolutely desperate to settle the case, then that really shifts the power dynamic considerably. And it can really change the way the case proceeds, because particularly in a very high conflict case where one spouse has, more of the power and control, whatever that looks like. Is it they have more resources to be able to grind the other spouse into the ground? Is it just a function of that power and control dynamic that's long been part of their relationship? If they can sniff out that you are desperate to settle, they will absolutely ensure that it doesn't. And I have seen it happen time and
you
time
describe it a little bit?
again.
I mean, I know, but what does it look like when somebody is desperate to settle? What does the other side often do?
They will just make sure it doesn't settle. They'll just keep throwing, gas on a flame. Prolong things, not respond to things, dragging their feet. There's nothing more annoying and upsetting to someone who just wants it to end, and then the other spouse is not, they're just off the radar. And then they're spending time and they're spending money with phone calls, emails, letters, trying to get the other side to re-engage. Or in the alternative, I have found that you also get all of these new issues being brought in, and they just are kind of red herrings. And it's like, okay, more issues, more time we have to spend addressing them. And particularly when they are non-issues, really at their core, that too becomes exceedingly frustrating and can become the impediment to ultimately getting over the line. In the alternative, I have found it is incredibly powerful to, no matter how desperate you are, you meaning client, to settle, you've got to make the other side believe that you're going to take it all the way. And if they believe that, and they think, that, oh, wow, like she's serious or he's serious, that can change things considerably. I've had really high conflict cases settled, mid-trial or just before, because we did exactly what we said we were going to do. Fine, you're going to push me? Fine, then we'll go all the way. And then you just start, whatever it is, there's a lot of things that you can serve on the other side, things that just show that you're moving the case forward. And for someone who's underestimated you for a long time, meaning, your spouse underestimating you, that sends a really powerful signal.
It's making me remember my own case to some extent, and the trial date was the thing that really got it. And we say that's often the thing that gets people to settle, is when trial is looming and you say, all right, I'm not going to, then we'll just spend another $50,000 another year. Like, that's what you want to do. And then, no, okay, we're done. But taking a year to get to that point and countless dollars spent. Yeah. Let's talk about goals and the idea of justice. Family courts, I'm gonna tell the judge my story. The judge is gonna hear me. The judge needs to understand where I'm coming from, and then they're gonna punish the other party. What do you think about that?
That is a very common goal. And unfortunately, particularly in a divorce, I mean, the courts are courts of equity. This is not criminal court where, justice, quote unquote, is served. It's just, that's not what a divorce is about. And I think that people do find it really disempowering, really disheartening, and exceedingly frustrating when the judge is just kind of moving the case along. Okay, we got to address this, we got to address this. They're not spending the time to say the things that the client wants to hear. Like, you're a wonderful mom. You've done a great job with your kids. You're a great father. You know, whatever the case may be, what they're looking for to hear, or you've been wronged and this is the person who wronged you. You know, and I can see that. I mean, judges don't do that. There are moments when I think judges can say things that mean a lot to clients, you know, and I've been in the room for those, and they're really, really powerful. And they do mean a lot, but they're not things that happen all the time. And I think if you walk into, particularly if you're in a situation where you're deciding, you know, court versus I'm going to try to resolve this another way, if your goal is to get into court because you want to hear those things and you want justice, then you will almost invariably.
Yeah, I mean, one of the things we hear, especially on social media, is like, judges don't care. Why don't judges have sympathy? They need to care. What do you think about that?
I think judges do care. They absolutely care. It's like anything else, right? I mean, some are better than others, but some lawyers are better than others. Some teachers are better than others. I mean, I think at least the bench, you know, where I practice, we have a really strong bench, really smart judges. But they're also seeing, you know, family after family after family. So and when you're in a court appearance, typically a court appearance, they're very narrow. There's very specific issues you are addressing during that appearance. It's not as though every time you walk in on an appearance, you're telling the judge every single thing that maybe your client would like them to hear. That is one way to really piss off a judge. And I completely understand from the client's point of view as to why it would feel that this judge doesn't care about me. This judge doesn't care about my children. So I oftentimes, you know, in preparing someone for a court appearance, I really try to prepare the client for, okay, this is what this judge is like. This is what you can expect. Because I think without that, they're walking in and they have no idea. And that also becomes a decision about, you know, how much do we want to litigate in front of this particular judge? Is this a judge that's going to be sympathetic to this issue? Is this a judge that's going to timely decide this issue? So I think really knowing the judges, having experience practicing before them is very, very important. And you had asked me previously, you know, do I take cases, you know, all over the state? And I don't. And that's the reason I don't, because you can't be in every place. So my sort of area of being in Manhattan and Brooklyn and Westchester, I know those judges, they know me. And there's a lot of value in that, to work with someone who really knows the players in those different areas. Like I think if someone hired me to take a case in Buffalo, I would want there to be, you know, a local counsel on the ground who really knew the judge. You know, sometimes I get brought in sort of like to strategize on a case that's not in Manhattan, Brooklyn, or Westchester, but I always think it's important if you're going to be litigating, you got to have someone local there. On the flip side,
we often feel, I know our clients often feel fear that judges and lawyers are friends and that that's going to impact the case. So if my ex's attorney is friends with the judge, then I'm going to lose the case because my attorney doesn't know the judge. What are your thoughts on that?
I think, again, that's totally case specific. I mean, I can understand the optics of that and the perception of that. I don't necessarily think as a bright line rule, you know, that's always accurate. So That's a harder
Okay.
one to answer.
All right, let me just check the time. All right, so let's get to a couple of other just questions that we came up with that I thought applied here too, considering our audience. One of them is that over COVID, we started doing a lot of remote appearances versus in-person appearances. And some people love it and some people don't. So what are your thoughts on remote versus in-person appearances? What are the pros and cons of each?
Sure. Certainly cost. Remote appearances, you save incredible time and incredible money having remote appearances. You're not paying for your attorney to travel to court. You're not paying for your attorney to sit there and wait, sometimes for hours, for the case to be called. With the remote appearances, I find on balance, it's very timely. If you get a link for a 10 o'clock appearance, everybody's in the link, and then you're done. So that is a definite pro. The con is interesting because it's not a con that was immediately evident to me. And it actually became much more evident when I was speaking to a judge. You know, in as much as it is more efficient, you lose being there. You lose a judge having access to the judge, having time, because you get into a remote appearance, and particularly if it's really contentious, okay, leave. I'm just logging off. I'm not sticking around. I'm not talking to anyone. I'm not saying to my adversary, hey, can we just talk off the record about this? Why don't we go ask the judge, see if he or she will have a conference with us for a few minutes. And particularly for cases that should settle and that don't, I think I've seen now, because particularly in Manhattan, they've really shifted. And the judges who know that, and know that if you're in the room with them, they can probably like bang your heads together to get it done. They're saying, come in person. No more remote. Nope, come in. And it's very effective.
Yeah, I do.
And I wouldn't have seen that from the get-go, but it's
yeah.
kind of fascinating.
One of the things that we've heard of with the DV cases is that certain clients prefer not to be in the same room as their adversary. Mm-hmm. But you didn't mention that as a pro or a con, but other people say, no, it's better to be in the same room because the judge can see the body language.
Well, definitely. I mean, I think that can be, it kind of speaks to the same issue. I mean, I've had clients who have said it is actually no less traumatizing to be in a Zoom or a Teams call, because although they're not in the same physical space, they can see the spouse just seething and staring at them in the video, where at least when you are in the same physical space in a courtroom, you're sitting at tables and you're facing the judge. You're not facing one another. So it can feel like you're being more shielded from that, but to see someone staring you down, and I've had to say, interrupt appearances to ask the court to direct, one spouse not to, make intimidating glances and, nefarious laughter, just horrible things. And judges have stopped that from happening. I've had judges kick people out of the virtual conference when they're just kind of going off the rails. So yeah, I mean, it's interesting, but to your point, yes, being in the same physical space can obviously feel awful. It gives that other spouse, particularly an abusive one, more access to you. They can follow you out of the courtroom. They can follow you to the subway. I mean, we're always on like very high alert for that, and make sure that we're covering all of our bases to make sure that doesn't happen. But it is a real concern nonetheless.
Yeah. You just reminded me of, because where we are with the bailiffs, will walk out with you, and they have monitors in the parking lot in Connecticut, but in New York they don't. But yeah, security is a huge issue outside of the courtroom, which a lot of people don't think about. Yeah. So
No,
speaking of
absolutely.
that, similar question-ish with mediation. Mediation is always something, again, much cheaper. People have a lot more control over their fates when they can come to some kind of agreement. But often people feel like it's not even worth it to try mediation if they're in that type of power dynamic where they feel like this is just going to be a waste of time and money. So what do you think with attempting mediation when there is, the power and control issue?
I think you have to be very, very, very careful, because when you are in mediation, most typically you are there without an advocate. And the mediator's job is not to advocate for either one of you. I mean, I work as a mediator, and my firm does as well. Certain attorneys in my firm do. And we really try to ask the right questions up front and screen people out who may not be appropriate. When that power dynamic is very evident, or even if it is not evident, based on things they're saying. Oh, we have an order of protection in place. It's like, okay, well then I don't think this is probably going to be appropriate. There's sometimes when people are a little bit on the line, where I think, well, it could go one of two ways, then I always strongly suggest that they have a consulting attorney on the side, that they are very clear with the mediator what types of ground rules need to be not only in place but enforced in order for the process to move forward. Because certainly while mediation is attractive to many people because of the perception that it's going to be cheaper, and oftentimes that perception is absolutely accurate, when it doesn't work, it can become just as expensive as another process, which could be more efficient if it's being, it's kind of more appropriately addressing those power dynamics so that the case can actually move forward. If someone doesn't feel empowered to speak up in a mediation where they're really being asked to advocate for themselves, then the process, can be much slower moving.
Yeah,
and ultimately
I was thinking as you were talking about open versus closed mediation. So I think closed mediation is when you're in separate rooms and the mediator goes back and forth, and open is when you're in the same room. Is that correct?
I haven't sort of heard it talked about like that, but I mean, yes, I mean, there's certain mediators who will caucus, which is that sense of, kind of moving in between rooms and having separate conversations. Some mediators feel strongly that that's not how they want to run a mediation, but those are good questions.
Yeah.
Those are good questions to ask. If you're thinking about mediation and you're trying to really understand like what the process looks like, then that's certainly a good question to ask.
Okay, so we're getting close to time, Kara, and I wasn't sure if there's anything else you wanted to say, or just how can people find you?
They can find me, I think easiest is through our website or my email. My email is easy. It's just Kara with a K, Kara at Rower LLC.com. Rower is ROWER. And our website is user-friendly. We do lots of different kinds of cases. I mean, I know we've sort of focused on, divorce in this conversation, but, I handle family court cases and orders of protection, child support, custody, when people are not married. Those cases get litigated in New York, at least. Those are family court cases, whereas divorce cases get litigated in Supreme Court.
Thank you so much for taking the time today and talking about all this stuff.
Of course.
All right.
Thank you, Lisa.
You're welcome. I'll talk to you later.